Welcome back to the channel. And buckle up because today's case is one of the most emotionally charged, legally complex, and ethically heavy hearings we've covered. We're talking about State versus Cullen Spencer O'Neill, a young defendant facing a potential 8-year cap for an offense involving a person he believed was just 15 years old. You're about to hear a mother's heartbreak, a community's shock, the state's fiery objections, and a judge wrestling with the weight of responsibility. As you watch this unfold, pay close attention to the inconsistencies, admissions, and the judge's reactions. They reveal everything about where this case is headed. And trust me, there are moments in this hearing that will leave you speechless. Right here, we see the emotional core of the defense's argument, the loss of Cullen's father. Notice how the mother stresses not only grief, but the absence of that father figure accountability. Defense attorneys often use this to humanize a defendant and highlight developmental instability, especially in young adults. But courts have to balance tragedy with responsibility. Many defendants experience trauma, but never commit serious offenses, so emotional hardship doesn't automatically justify leniency. What do you think? Does parental loss help explain behavior? Or should the court focus strictly on actions? This is one of those critical turning points where character evidence clashes with the severity of the crime. The mother insists the behavior was totally out of character and emphasizes decades of clean conduct. But remember, great character does not erase legally documented actions, especially in crimes involving minors. Judges often give weight to character, but only when paired with genuine accountability. The mother is painting Cullen as someone who made a single terrible mistake, not a habitual offender. The question is whether the court agrees or whether the state's concerns about public safety outweigh all of this supportive testimony. Here we see the defense's foundation. Cullen has a support network, stable upbringing, long-term friendships, and the ability to comply with structured supervision. They're building the case that probation isn't just mercy. It's a strategic investment in rehabilitation. Courts love to see defendants already demonstrating compliance, like completing a year and a half on an ankle monitor without violations. But probation for offenses involving minors is rare and controversial. This testimony sets up a tension that will define the entire hearing. Should rehabilitation take priority over punishment when a minor is involved? The second witness doubles down on the portrayal of Cullen as respectful, well-raised, and consistently appropriate around peers. Statements like, right is right and wrong is wrong, help the defense argue Cullen wasn't predatory, but rather a young man who made a catastrophic lapse in judgment. This is powerful because she's not family. She's a longtime family friend, and courts often view non-family character witnesses as more credible. But again, the judge must weigh community testimony against the explicit, graphic communications documented in the case record. This is where facts and feelings collide in sentencing. Melissa's testimony adds another layer. Cullen wasn't just well-behaved with adults. He was trusted around other children and welcomed into homes. This matters because it establishes a long-term behavioral pattern inconsistent with predatory tendencies. Defense is stacking witness after witness to show a stable, pro-social history. Courts consider patterns over time, but a single severe offense can still overshadow years of good conduct. This testimony is compelling, but the ultimate question for the judge will be whether Cullen's demonstrated character outweighs the risk highlighted by the prosecution. This is one of the most important shifts in any sentencing hearing when the defendant speaks. Judges aren't just listening to words, they're evaluating sincerity, remorse, clarity, and responsibility. Cullen openly admits to being under the influence and making an egregious mistake, which shows honesty, but also raises concerns about decision-making. Courts scrutinize whether defendants blame external factors or accept full accountability. His statement, "I'm willing to take it on the chin," signals responsibility, but whether the judge buys it is another story. Question for you. Do you feel Cullen sounds genuinely remorseful here? Why or why not? Cullen's admission of drug and alcohol issues is important because it cuts both ways legally. On one hand, it supports the defense argument for treatment-based probation. On the other, it signals impaired judgment and potential risk to the community. Judges often look at how long the substance use lasted, what steps the defendant has taken toward sobriety, and whether the offense was directly influenced by intoxication. Cullen's claim that he has stopped using since being on house arrest may help, but courts are wary of behavior motivated by monitoring rather than internal change. This is arguably the most damning moment of Cullen's testimony. He openly admits he knew the girl was 15 and still intended to engage in sexual conduct. Legally, this establishes full criminal intent, the bedrock of the prosecution's case. His explanation about exhaustion and emotional vulnerability may humanize him, but does not mitigate legal responsibility. Judges often look for this exact admission because it clarifies whether the decision was deliberate or accidental. And here, Cullen clearly states it was intentional, even if influenced by substances. This admission will weigh heavily in the judge's final decision. The prosecutor zeroes in on a critical theme: minimization. She argues Cullen consistently downplayed his actions, from the undercover conversation to the PSI interview. In cases like this, judges take minimization very seriously because it signals potential danger and a lack of rehabilitation readiness. The prosecutor also emphasizes the graphic and violent nature of Cullen's messages. This detail is huge. Graphic intent weighs more heavily than generic agreement to meet. By highlighting both the content and Cullen's attempts to avoid paper trails, the prosecutor is building an argument that Cullen is not a naive young man, but someone aware enough to conceal wrongdoing. At this point, all of the emotional testimony, legal arguments, and personal statements have been weighed. Notice how the judge highlights Chapter 62 compliance. That means mandatory sex offender registration. This is life-altering and significantly influences future employment, housing, and social relationships. The judge is signaling that despite the supportive witnesses, the severity of the offense demands accountability. Cullen's reaction, asking to hug his mother, underscores how crushing the moment is. Judges rarely allow physical contact once sentencing is pronounced, especially in felony cases. The judge acknowledges defense counsel's request regarding jurisdiction, which hints at potential future motions, possibly for shock probation or judicial review. This shows the case isn't fully over, even after sentencing. Defense attorneys often file post-sentencing motions seeking early release options if the defendant demonstrates exceptional behavior. Whether this will succeed is uncertain, but the judge leaving the door open suggests she's willing to review, but not guarantee, future reconsideration. This case highlights the difficult balance courts face, weighing a young defendant's potential for rehabilitation against the profound seriousness of attempting to engage in sexual conduct with a minor. The defense presented a strong support system, long-term character evidence, and arguments for treatment-based probation. The prosecution countered with concerns about public safety, minimization, and the graphic nature of the communications. In the end, the judge imposed a 3-year prison sentence with Chapter 62 requirements, demonstrating that remorse and community support cannot overcome the need for accountability in crimes involving minors. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, And don't forget to subscribe for more jaw-dropping courtroom breakdowns.